There's a huge difference between a rescission letter and a material change letter, which is what we're going to talk about today. One of them, you're admitting that you violated securities laws. The other one, you have not. All right, well, welcome back to episode 36 of the Real Estate Syndicator Live. And today's topic is on material changes. This is when something changes in your syndication prior to close, right? So something happens prior to close, but after your investors have already given you your money, what do? Probably the most common scenarios these days that we're seeing are, you're a little short on the raise and you want to bring in a private equity group, for example, to finish up the raise. Or maybe there's an investor out there that's got $1 million that, you'd really like to bring in, but they've got different terms that you've already disclosed to everyone. Or maybe they're doing a 1031 exchange or something that you hadn't thought about, but somebody can bring in $1 million or $2 million, which would really help you, but it's going to have to be a 1031, which means the whole structure changes. Those are all kind of changes that happen. And then the question becomes, what do you need to do? The other change that can happen, that hasn't happened too often, but the other one that happens every so often is you just blow the exemption. You're doing a 506B and one of your GPs inadvertently, maybe as a first-time syndicator, put something on social media or something, and you're like, crap, we kind of officially blew the 506B exemption. What do I do? There's a huge difference between a rescission letter and a material change letter, which is what we're going to talk about today. One of them, you're admitting that you violated securities laws. The other one, you have not. So generally speaking, as you guys know, you have an obligation to disclose all of the material facts to your investors, right? We always talk about this idea that, look, the whole point of a PPM is to make sure that your investors go into your deal with eyes wide open. You've disclosed all the material facts in your deal so that they can make an intelligent decision whether to invest in your deal or not. And so the question always becomes, well, what is a material fact, right? And let me give you the definition, and then you can see that it's relatively subjective and open to interpretation. But a material fact is anything that a reasonable investor would consider as relevant or important in their decision-making process, right? So if an investor said, look, that's important enough of a fact that had I known that, could have dictated the direction of my investment, whether I would have invested or not invested, or maybe invested more. And so, that's kind of a judgment call, right? My concern is always that because it's really easy to argue that things are material, we always like to err on the cautious side. So if there is some kind of a change and we're kind of in the gray zone, and we're like, well, is that a material or not material? It's always, in my opinion, sort of err on the side of caution and say, let's just call it a material fact that's changing, and let's give notice to the investors. But let's talk about the difference here, because most of the time, and in fact, I'm trying to remember off the top of my head whether we've actually done, or we have done at least one rescission letter, but let's talk about rescission letters first. Let's get that out of the way, because it's not something that you're probably going to see too much. But a rescission letter is something that you prepare when you know, or you at least have a belief that you violated securities laws, right? So, but for example, the last example I gave you guys with the GP and advertising, like you're doing a 506B and somebody somebody not knowing or not thinking put a blatant post or spoke about it on a platform on social media, and you're like, crap, this violates 506B. And so now, we've blown that exemption, what do we do? So that's where a rescission offer comes into play, where you basically write a very strict letter to all of your investors and say, look, it's come to our attention that we may have violated securities laws for the following reasons. And because of that, we're giving you the opportunity to back out of the deal if you so desire. You typically give them an explanation. Sometimes it's, not a big deal. It's innocuous, or maybe it's just, hey, we inadvertently did something. And so it's a violation of securities laws that you're actually admitted to. And so you're going back there and you say, look, we've violated securities laws. And so I'm offering for us to basically buy your shares back from you, rescind the transaction, give you all your money back plus interest. And that's the key there as well. You got to give them best interest. But the key of that letter is to just make it very clear to the investor that they do have an option to back out, right? That's what a rescission letter is, right? You violated securities laws. Like I said, I think we've only dealt with that once, and I can't even remember, to be honest with you, the details of it, but we have written one rescission letter. What we typically do is what we call a material change letter. And that's different in the fact that it's something that came up after the fact, but you're not violating securities laws. It's just a change of facts. For example, the one I just said, hey, look, I want to bring in 1031 investors, but nowhere in my documents, well, I wasn't even contemplated. So nowhere in the PPM is there any reference to a 1031 investor. And there's no reference to, if you guys have done 1031s, it's a completely different structure. So now we have to go back and restructure it, literally create, different tenants in common agreements. And it's a completely new structure. So that's a material change, but you haven't violated any securities laws. It's just like you just made a decision that this is something that you want to change. Similarly, people want to bring in, $1 million investor comes in and says, hey, I got $1 million, but you know what? I don't want the usual, whatever you're giving your other investors, 80-20 or 70-30. I want 10% pref. I want first in and first out. And I want, veto power on this or this, whatever their demands are. Again, you haven't violated securities law by agreeing, hey, I want this person actually to come in. It's worth for me to give up whatever they want for the change. But that's what I would consider a material change. And that's something that you want to go back to your investors and you want to write that letter that says, hey, I know that you read all the disclosures that we gave you, which at the time, by the way, were accurate. So when we prepared that PPM, when we prepared that business plan, you had all the material facts, but something has changed, whether it's your fault or, whatever the circumstances are, but there's a change. So if you don't like the change, here's the change. If you don't like the change, we're going to give you an opportunity to back out of the deal because we understand that when you gave us the money, that's not something that was contemplated. And again, because it's very easy for someone to, I want to say someone, I really mean plaintiffs' lawyers. It's very easy for plaintiffs' lawyers in the future. I mean, just put yourself in their shoes. Let's just fast forward 5 years. And let's just say the investment went south for whatever reason, no reason, maybe not even any fault of your own, but the investment went south. Investors have lost some of their money or all of their money. Now they're reaching out to plaintiffs' lawyers. What do you think the plaintiffs' lawyers are going to be doing? They're going to be saying, look, had you disclosed to me that, XYZ, there's no way my client would have invested in your deal, right? And you've created that sort of, well, who's right? Is that really a reasonable decision? Is that really something is that true or not? It's very difficult to obviously prove. But it's going to be, it's going to be our burden to see whether a reasonable investor, would have made that decision had they known at that time. So we always err on the side of caution, but understanding, of course, that a rescission sometimes isn't very practical, right? Because at the end of the day, you especially if you've already done something with the money, but if you're about to close and the idea of giving all your investors their money back in whatever interest, and interest shouldn't be a big deal. It's going to be legal rate, but at the end of the day, you probably had their money for 1 or 2 months at most. So it's probably not going to be a huge deal, but you want to give them that option because even though, at the federal level, the rescission doesn't necessarily extinguish liability, because think about it, we always talk about the violation or the securities laws apply at the time of sale, right? So, and I always say, once the sale happens, once that cat is out of the bag, you can't stick that cat back in the bag. And so you're still theoretically, if you're in violation of securities laws, or if that material change happens, it's not, that part hasn't changed. But when you give somebody the option to get their money back, then you get into a situation where they're sort of, okay, well, what are your damages? Like, even if it's true that, you would not have invested had you known this material fact, at the end of the day, there's no damages because we gave you the opportunity to back out. Now, at the state level, there's a lot of, I think most of the states, I think all but 3 or 4 actually have statutes in there that says, hey, if you refuse a rescission offer, so if syndicator says, Mr. or Mrs. Investor, here's your money back if you don't want to do it, and I decline that and continue in the deal, I'm going to be barred from actually coming after you. So, so those are really the main things that we look at is whenever there's a material change where we believe it's significant enough that a reasonable investor could argue that had that change not happened, or had they known about that change, they would have invested in the first place, then it's probably a good idea to do a rescission letter. I'm sorry, a material change letter. And the reality is the ones that we've done generally don't result in a mass exodus, because again, most of these material changes, even though they are material, most investors don't think they're that big of a deal. And so best practices that we always recommend is to, before sending out a material change letter, just to pick up the phone and call all of your investors that are already in, say, hey, look, here's the change that's happened. I still think this is a great deal. This is still, I still believe in this. It's not going to change the returns that much or at all, or maybe they change in your favor, but legally, or blame it on the lawyers. My attorney is insisting that I send you this letter. So you're going to be receiving a letter from us, giving you the opportunity to back out. And if you want to back out, but we still like it. So anyway, so as you can see, the topic of materiality is very subjective, but it's something that you just have to have that discussion with your attorney and be comfortable. Again, some syndicators are much more conservative than others, and some like to roll the dice, and something I may think is on the gray area and think, maybe we should, do a material change letter. And some syndicators say, no, I'm good with it. I'm willing to take whatever risk because I don't think it's that big of a deal, especially if you're about to close right in 2 or 3 days. So anyway, I think that's kind of what I wanted to talk about that. I'm sure there's going to be some questions on your definitions. Again, the only one other thing I will comment on is that this obviously pertains to stuff that happens prior to the close. If something were to happen, and it has happened before, where some information, you find out some information from the seller sometimes, or you just find out something about the property after close. You didn't even know about it. As a reasonable syndicator, you wouldn't have known about it, but something you discover after the close, that's a little bit of a different game, because at that point, the money's been spent, right? You bought the property, you didn't know about it. It's probably a good idea to disclose that to your investors, probably in your quarterly report, and say, hey, look, we just found out that this property, insert here, has some mold that we didn't know of before, or, whatever the issue is. But at that point, obviously, it's not realistic to do a rescission or a material change letter, because it's already been closed, and you didn't know that yourself, or actually whether you knew it or not doesn't really matter. It's whether a reasonably prudent syndicator under the circumstances should have known that information was out there, and if you were good there, then we wouldn't expect you to do that. So anyway, that was kind of my my little rant for today, a little bit shorter than usual, but I know that this is a topic that's come up, so I wanted to address it, and certainly want to address any specific questions. Let's do them on these topics first. If you want to have a question in the chat, let me know. Question is, I'm going to be trying to do a 1031 starting this month. I would like to know more about what I need to do. We actually did an episode early on. I think it was episode 5 or 6 or 10 or somewhere around there. We did a whole episode on 1031s. And well, let's talk about that really quickly. There's actually no limitation from an SEC perspective. So when you're doing a 1031 as a syndicator, from my perspective, you can do whatever you want. You come to me and you say, hey, Mauricio, this is how I want to structure it. From my perspective, SEC perspective, no problem. Do it however you want, as long as we're disclosing everything. The challenge comes from the IRS, right? So the IRS does have some limitations, which is why we usually recommend or really insist that you speak not only to your CPA and get the sign off from your CPA, but also the CPA of the 1031 investor coming in and making sure that they're all good. But there's about 15 limitations that the IRS imposes on syndicators, of which about 3 or 4 are really relevant. And this is all found in, I've got always dyslexia on this one, but it's Revenue Procedure Code. I think it's 2002-20 or 2002-22, but there's a list of 15, and we go through all of those in the episode. But the main one that you've got to be concerned about is that, and this is kind of the drawback of a 1031 in a syndication, is that, first of all, the structure is, if you guys don't know the structure of it, basically what we need to do is the investor that comes in a 1031 has to relinquish the property, obviously, that they have presumably in their personal name or in the name of whatever LLC. They've got to take direct title. Otherwise, the 1031 doesn't work, right? You can't go from a direct title to shares in your LLC or membership units in your LLC. They've got to have direct title. So what generally happens is the syndication LLC that you're raising the capital to will end up raising less than 100% of the money. So they'll raise, let's just say 85%, let's make it easy. 90% of the money is raised into the syndication LLC. And then the 1031 investor brings in the additional 10%. So it's a 90-10 ownership structure that's tied together with a tenants in common agreement. So if you look at the deed on the property will actually say syndication LLC owns 90%, John Doe owns 10%, and we have a tenants in common agreement that ties it all together very nicely. But the challenge is that per IRS regulations, you have to distribute any monies proportionally, right? So you cannot do preferred returns. You cannot do a carried interest on that 10%, right? So in my example, if you've got $100 at the end of the quarter to distribute to your investors, $90 has to go to the syndication LLC and $10 has to go to your 1031 investor, right? Once that $90 gets into your syndication LLC, then you can split that however you want. If you want to do an 8% pref and then 80-20 or 50-50 or whatever you want to do in the inside the syndication LLC, knock yourself out. But you cannot do a pref to the 1031 investor. You can't do an 80-20 split with the 1031 investor, the 1031 investor must receive a proportional distribution from ownership. Now, you can take a reasonable asset management fee, you can take a reasonable acquisition fee, but again, that has to be paid proportionally. So 90% of the asset management fee has to be paid by the syndication LLC, 10% of it has to be paid by the 1031 investor. And so there are some limitations, and that's why we want to talk to the CPAs. And then there's some additional risks, right? Because even though we're going to draft or if you want to say it's usually the real estate attorney that drafts the TIC agreement, the tenants in common agreement, the 1031 investor has sort of veto power, right? Even if you try and draft into the documents that, you as a sponsor have all the management control, at the end of the day, when you're about to sell that property, the title company for sure, and probably the seller is going to want to have the signature of both owners. And so if for whatever reason, the 1031 investor, doesn't want to sell or whatever is giving you a hard time, that they do kind of have veto power over that. Not to mention that there's always the additional risk that their 1031 is blown. For whatever reason, you think it's a clean 1031, and that's why you want the CPAs to sign off on it, because if at the end of the day it gets blown, there's a risk that the 1031 investor comes after the sponsor and sues the whole LLC, which obviously affects all the other investors. So there's some additional risk disclosures, but the primary limitations are those 15 that is part of the IRS revenue procedure code that we just went through. So anyway, hopefully that answered the question, Andrea, and thanks so much for getting up at 2:30 in the morning. Really, really appreciate that. Dan's asking, if you found out that a seller falsified P&Ls after the purchase and entered into litigation against the seller, are there any limitations in sharing info with LPs? If you found out that a seller falsified P&Ls, okay, after the purchase and entered into litigation, are there any limitations in sharing that? No, in fact, I would definitely be letting them know right away, right? Because obviously that part's not your fault, but you definitely have a fiduciary responsibility to your investors. And so actually going after the seller is probably part of that fiduciary responsibilities, right? So no, I mean, the LPs are the owner. So when you say you are going after the seller, it's really the LLC that you represent and that you're a fiduciary for. So I would let them know immediately. Actually, I wouldn't even wait until the quarterly reports to let them know. I would let them know immediately. Hey, this is what happened. We didn't know. Hopefully that was something that was, hopefully you didn't know because there was no way for you to know. Obviously, if somebody's falsifying P&Ls, the risk is always just the biggest risk. And this is not really a securities question or comment that I'm about to make. This goes back to my litigation days, but the biggest risk that you are seeing with falsified P&Ls is, should you have found out I guess if somebody's completely falsifying, but, do you have processes and procedures in place to kind of, do this? And your standard is you must, just like what we just talked about, material changes, you must act like a reasonable, prudent syndicator would under the circumstances. So if you meet that burden, if you acted reasonably and like a reasonable, prudent syndicator would, then you've got nothing to worry about. If on the other hand, there were some red flags that you just didn't pick up because, maybe this is your first syndication and you just didn't know, and a more experienced syndicator would have picked that up. That's when you might get into some issues, which is why it's so important to make sure that you're doing your due diligence on everything. But generally speaking, let's assuming it's flat out falsified. I don't know how you found out later, but I would not only alert your LPs right away, I would also then give them periodic updates, probably in every quarterly report. Even if there's nothing too much to report, just let them know, hey, not much to report or nothing to report since the last one. So, all right, cool. Well, everyone said it sounds like an hour works good. So appreciate that. Longer is better. I want to learn as much as I can. Thanks, Andrea. Appreciate it. Sean says difference between 506C, Reg-CF Title III fund. Difference between a 506C and a regulation crowdfunding fund. Well, the fact that it's a fund doesn't matter, right? So the fund is just the structure, right? We talked about that. Well, actually, last week we talked about fund of funds. I think our second episode was on funds in general. So, whether it's a 506C or Reg-CF or 506B or Reg-A, whatever exemption you're picking is separate and apart from the actual fund structure. And when we say a fund, what we're basically talking about, obviously, is raising the money ahead of time before you identify properties, raise the money into your LLC, then go out and find the properties once you have the money in the bank, versus a project specific deal where you actually identify the property first and then you go raise specifically for that project. But the difference is with, Reg-CF, simply off the top of my head, because we don't do any CFs, it hasn't been very popular, to be honest with you. But I did do an article, I think, The Good, the Bad, and the Ugly on regulated crowdfunding when it came out. But so 506c, nice thing about 506c is you can advertise, you can generally solicit, you can do that on your own website. You can basically do almost anything you want, so long as you don't violate the anti-fraud provisions. You just have to make sure that you limit your investors to accredited investors only, and you take reasonable steps to verify. So that's kind of the 506c. Reg-CF was meant to sort of allow non-accredited investors and advertise. It was almost like a sort of a Reg A, mini Reg A or something. But the challenge with the Reg-CF is as follows. Number one, you're limited to how much you can raise in a 12-month period. It started off at $1 million, and now that's been adjusted up for, it gets adjusted for inflation. It's a little bit more than $1 million, but still it's $1 million in a 12-month period, which isn't a lot, right? The other thing that's misleading is that even though you can advertise, you really can't. First of all, you have to go through a portal. You have to go through either a broker dealer or an SEC licensed portal. You can't just use your own website. You can't use your own Facebook group. You have to go through one of these licensed entities, which of course cost money, and they charge their things. Most of them are broker dealers. But all you can really do is do one of these kind of tombstone ads and then show a link to that portal and point them to the direction of the portal, and the portal then does all the advertising for you. So you can say, hey, I'm raising $1 million to go buy a 100-unit apartment building in Spokane, Washington. For more details, check out the link here. And then they go to the link there. You can't do it on your own website. You can't, obviously you can do some social media ads, but it's just kind of general advertising to then point to the portal. And then the other thing you got to remember is, there's significant limitations on the non-accredited, not as to the amount, but the amount of non-accredited, but how much they can invest, right? So they can only invest, I think this has changed a little bit too, but they can only invest, I believe it was the lesser of 5% of their net worth or income, whichever is lowest, which also is weird because a lot of times you can have some accredited investors that theoretically, actually like not Warren Buffett, but there's a lot of these huge billionaires that basically take $1 in salary. And I'm like, well, that technically makes them now non-accredited for purposes of Reg-CF because it's the lower of their net worth or income. And if their income's $1, because that's what they're taking, they technically are non-accredited. But you can only take the lesser of, so it's 5%, or I think it was $2,500. So it's a very small amount. So you end up with a ton of, small numbers. So those are kind of the big differences. I've never done a CF because I haven't found anybody that's really interested in doing one. There's also, as a syndicator, there's all these compliance nonsense that you have to deal with depending on how much you're raising. If it's less than 250, between 250 and 500, or over 500, you've got to provide some level of financial disclosures and all this compliance stuff. So if anybody's done a CF, I'd be interested in. Do you want to drop a comment in there? The only time I think would be that I've thought about would be a good enough idea is if you did them both, because you can do concurrent raises, right? I can do a 506c and I can do a Reg-CF at the same time. So I could see raising, if you're raising $3 million and you get $2 million from a 506c or a 506b, and then another $1 million from this other one, theoretically could work. But the cost was prohibitive, and I don't know, nobody seemed to be that interested in doing it.
Yeah. So basically, recently I came across a syndicator. He's sending out the PPM documents, and he's closing the deal in December, and he's keeping the PPM open active until April. Is it allowed to raise the funds after they close the deal?
Yeah, as long as you disclose it. So the question is, can you continue to raise post-close? Can you continue to raise money after the close? And the answer is yes, and it's fairly common actually. What typically happens is you raise enough money. Once you get enough money to actually close on the deal, so whatever the down payment is at a minimum, and then, sometimes you also raise, but, you may just be short by 50 or 100 grand. So maybe you're not taking your acquisition fee, or you're not, maybe there's some future value add, but you feel comfortable that you've got enough to close and not put the project in jeopardy. Obviously, you don't want to close and suddenly, because you don't have a dime in the bank, that's going to jeopardize something. But generally speaking, you want to disclose that, right? You want to make sure that in your PPM doc, you do give yourself the option to do that. And again, it's not super uncommon. You just hold, there's some expenses you just don't need right at close, like your fees, for example, which are sometimes, significant. There might be 6 figures, your acquisition fee, you can raise that last 100 grand or 200 grand after the close. So yes, that's something you can absolutely do. And again, it's relatively common. in a TIC agreement, a tenants in common agreement, does every partner have to bring value outside of money? Can a partner be a completely passive without breaking any rules? I think the way you frame the question is a little bit weird when you say, can a partner be completely passive? So it's not in the 1031 example, for example, the 1031 investor is passive, right? So they're not involved in, they're going to put a lot of money into your deal. They just happen to come from a 1031 and they're relinquishing property and they got to go through that whole thing. But at the end of the day, they're just a passive investors like everybody else. So that happens quite a bit. When you're doing a 1031 with a passive investor, or I guess any TIC agreement where you have a passive investor, you're technically doing two separate syndications, right? You're doing the syndication that we all know about, which is you're raising all the money from your passive investors, except for the 1031, all the money into your syndication LLC. That's one syndication. And then there's the syndication with your passive investor. That second one at the TIC level is technically another separate syndication. Now, a lot of times that's an easy 506B because you have a pre-existing relationship with them and all that stuff, but they're a passive investor. They're not part of the syndication LLC. So giving them the PPM and saying, hey, we're raising $5 million and you're going to own a share, that's not relevant to the 1031 person. So just be careful about that if they're passive. Sometimes though, the partners themselves, and we used to do these in the past, the GPs want to hold their interest as a TIC because they want to have the opportunity to 1031 out. And so I have had deals where, let's say it's an 80-20 deal, instead of doing an 80-20 inside the LLC, it'll be, 10, let's say there's two sponsors, then they'll each take 10% direct title. And then the syndication LLC will own 80%. All of that money will go to the investors. That way the sponsors have an option to 1031, or that's usually why they want to do it. But if they're completely passive, that's fine. There's no issues there. It just means that you're technically doing two syndications. So just make sure you've got the right exemption for that second one, and make sure you're filing you're going to end up filing two Form Ds, one for the syndication and one for the TIC. Back to the 1031 exchange question. Assuming there is more than one investor, do all of the investors in the TIC? Oh, so I'm assuming this is your question. In a scenario where you've got a TIC arrangement where maybe one of the TIC members is a 1031, but maybe one or more of the other ones are not, which again, you could structure it however you want, right? As long as it's being disclosed. Then no, I mean, I'm not a 1031 expert by any means, and I'm certainly not a CPA, but I don't know why the non-1031 people would have to do anything and go through an intermediary or anything like that. The syndication LLC is certainly not doing that. So you just need to go through making sure they're part of the TIC agreement. One of the other things that a lender, and I'm not a lender either, and lenders will typically want the TIC. If you have direct title and you own more than 10% of the TIC, you're probably going to want to get underwritten. No, there's no reason for those non 1031 TIC members to have to go through the intermediary process if they're not doing a 1031. Mickey, from my understanding, lenders are not as keen on projects with tenants in common. What have you seen? I haven't seen any issues. Lenders actually have their own, they have their own thing, right? So we used to draft our own TIC agreement, all this stuff. And then I realized, what? The lenders have their own templates. And so I just gave up. I just give me your template. They give you a template with all the blanks and I don't like it, but it makes everyone's life easier because you're using the bank's template. Obviously, you're going to make sure that, we're putting all the provisions in there that protects clients and everything like that. But the banks are aware of them. And like I said, we do a fair amount of these TIC arrangements, whether they're mostly 1031 deals now. And I haven't had any pushback from lenders. In fact, they were already ready to go with their own requirements. And they do have their requirements, right? So they do have, they're going to want to have one, they don't want to talk to 10 TIC members or 2 TIC members. They're going to want to have one person that's the point of contact. They want to have, all the contracts in place, but I have not seen any pushback, Mickey, from lenders. Fatty's in the house. Hey, Fatty, how are you? If LP decides to give up US citizenship, would it be enough to have LP create a US LLC and transfer units to US LLC before giving up citizenship? Enough for what? I mean, at that point, you're not worried about securities laws because the sale already happened, right? So usually when you're dealing with a non-US person, There's all those things that we've talked about before when you're having international investors trying to figure out what, just making sure you're complying with the rules over there, whatever country they're in, and make sure that you're doing the 30% withholding and sending that money to the treasury, and just making sure there's a bunch of things that we've gone through before. But I mean, I think from my perspective, as long as the transfer, let's talk about transfers real quick, actually. So when you're doing a transfer from an individual to an LLC, or from one LLC to another LLC, the key is just to make sure the ownership is identical, right? So if you have an LLC, if you're an LP in a deal and you want to transfer it to your living trust, obviously that's easy. Or if you have a holding company, you've done the asset protection stuff, you met with your asset protection attorney, they've created a Wyoming holding company, then you can easily transfer that interest from your personal name into that holding company. What you want to be careful about is when you transfer interest that you own personally to an LLC that's owned by somebody else as well, right? Maybe it's even a spouse theoretically, because that's going to be considered a sale. But if this person is simply renouncing U.S. citizenship and they want to then create a U.S. LLC and transfer units to the U.S. LLC before, I mean, that happens almost automatically. So if they want to create a U.S. LLC and transfer the units over there, that's from a security standpoint, and from an operational standpoint, that's fine. Whether that's going to avoid, maybe that's the question, if that's going to avoid a tax hit or whatever, I don't know. But certainly from a structural, from a security standpoint, that shouldn't be an issue. I'm just not clear. I don't know if you're on, Fatty, enough for what? The question is, would it be enough? Would it be enough? And I'm not sure what that enough is for. I would like to learn more about how to tell potential investors about investment opportunity. Well, it depends on what exemption. This is one of the reasons we like to suggest that you call us or your securities attorney early in the process, because what exemption you and your attorney end up deciding on is going to dictate what you can and cannot say to potential investors, right? So if you decide you're going to do a 506B, well, then you generally want to have pre-existing relationships with those substantive relationships with those investors before you start talking about anything. On the other hand, if you're doing a 506C, then, go grab lunch and have phone calls with whoever you want. It doesn't really matter. So it all comes down on what exemption you're going to be picking on. If there's an investment opportunity that's already in the works, then I'd just be careful to show them anything that hasn't been already run by your SEC counsel. So if you want to show them a pitch deck or spreadsheets, just make sure that we do that. I mean, that's the first thing we do, is look at your business plan and make sure we make all the proper disclaimers or disclosures. The one of the things I'm probably going to do some content on is the SEC governs not only the sale of securities, but the offers. And so if you're out there talking to people and showing them spreadsheets and showing them the stuff, you could potentially be making offers. And if you don't have all the proper disclaimers in there, that becomes problematic. So the best practices, I would say, is whatever you're going to put together, if it's not the full-blown business plan, maybe you're not there yet and you want to put together a 1-sheet or a 4-page, summary, like a short version of it, send it to your securities attorney, make sure they have all the disclaimers. They'll have the disclaimers in there. Hey, this is not an offer. This is to gauge interest. This is whatever the disclaimers are, so that there's no issues of you actually, making sort of an unregistered offering to the investors. But it really depends on the exemption, because if you're doing a 506B, then there's, you want to make sure you're qualifying the investors before you even talk about the opportunity. Shecky, welcome. First time tuning in. Would like to listen to previous webinar on the fund to fund info. It's actually, I think, my main video on the YouTube channel. So if you guys, by the way, if you guys aren't on the YouTube channel, or if you haven't checked out the channel, I really would appreciate it. I'm trying to get some subscribers in there and build the channel up. So if you are finding value in these things, please appreciate you guys going. You can go, it's just Mauricio Rauld. It's my personal YouTube channel. I put all the videos up there, trying to put out as much content as I can. Sean, 2 questions. 1, 506C fund, new construction assets, typical development fee. Usually we see, and I should probably give you a range, but the number that always, and if somebody else has different answers, the ones that I typically see is a 5% construction management fee. Not all taken obviously at close. It gets taken out for the processes, but I typically see a 5% construction management fee. But there's nothing that says you can't take more or less. But maybe just like I say, the standard structure is an 80-20 split. I would say the standard construction management fee is 5%. And then number 2, if the GP already has acquired land and wants to exit the land to the fund, yep. Can GP sell it to the fund at market value? 100%. Assuming market value has increased since purchase of land. Yeah. So the question essentially is, if I buy a piece of property for a dollar, and then by the time I'm ready to go syndicate it, it's worth $3, and I want to contribute that land, either sell it to the fund or contribute it as my equity, however you want, you can absolutely sell it to the fund or, value it at the market value of 3%. You just got to disclose it. It's kind of like, it's part of what I would call indirect compensation. It's not really direct compensation, but it's definitely a benefit that you are getting. And, potentially somebody could argue it's a conflict of interest, but again, I would just disclose that, and we would disclose the potential conflict. But if you can show, appraisals or whatever, and honestly, to be honest with you, again, you can literally say, look, I bought it for $1. I'm selling it for $3. It's just my belief of what it's worth. I don't have anything to support. As long as you're disclosing that stuff, you're going to be in good shape, right? Because then the investor can just decide, hey, I still like the deal, I don't like the deal. But yeah, having an appraisal or a broker price opinion, absolutely, that happens all the time. Mickey, what are the current guidelines for concurrent offerings? If one is a 506B, and does the other also have to be a B, even if unrelated? I was thinking that there were restrictions on concurrent offerings. So you can always do concurrent offerings, although with the new rules, which I hope you guys by now know about them because I've done quite a bit of content on it. The new rules now actually allow you to pivot from a 506B to a 506C. So if you're thinking about doing, although I guess you're talking about two completely different offerings. So let me just backtrack. You can always do concurrent offerings. There's nothing wrong with doing not only two 506Bs, but you could theoretically do a 506C and a 506B at the same time, two completely different deals. You have two projects, two apartment buildings that you're under contract. You want to raise them separately, and one's a 506B, one's a 506C. You just got to be very, very careful. You got to draw that proverbial Chinese wall and just make sure that the 506B, you're fully complying with that. So there's no general solicitation, there's no advertising. Generally, to be safe, usually when you do concurrent offerings, you're literally almost picking up the phone. That's probably the safest way, where you're picking up the phone and making a few phone calls and raising a smaller raise over there. But if you can show that you did not mix and match those two offerings, you're going to be good. Now, what you cannot do, and I got this today somewhere, I think on the Facebook group, what you cannot do is if somebody calls you for the 506C deal, say, hey, sorry, and they're not accredited. Hey, sorry, you're not eligible for my 506C deal, but hey, I've got a 506B over here. Why don't you go in there? That's not going to fly for a variety of different reasons. The least of which is you most likely don't have a pre-existing substantive relationship with that person, because but more importantly, you found them through a general solicitation advertising. So what I would do with those people is I would actually not offer them that concurrent deal, but I would go through the 8 steps to take them from a complete stranger to somebody you have a substantive relationship with, and then make them eligible for a future deal. But I would not take a non-accredited from a 506B and stick them into your concurrent 506B. But legally speaking, maybe practically speaking, it might be a tough one. But from a legal perspective, you can absolutely do concurrent raises, and especially if they're two completely separate projects. Then as long as you can show that you're not mixing and matching and it's very clear, then you should be fine. Dave and Cindy, what are those 8 steps? You know what? I was going to do a YouTube short. I'm trying to be a little bit more creative. So the 8 steps, I think I'm actually going to do a flip chart Friday of it. There's a video I did also on I think it's how to be compensated. Anyway, it doesn't matter. 8 steps. So in order to take somebody from a complete stranger to somebody you have a substantive relationship, I don't think I've got them all memorized. The main ones are, number one, you want to send them a questionnaire. And the questionnaire is a pretty detailed questionnaire. It's not just, are you accredited? How much money do you make? But it's all your goals. Are you conservative? Are you, what your experience levels are? It's almost like that questionnaire when you set up a margin account or a stock account. I have one. If you want to, how do you get a copy of this? I have an ebook called The 5 Things Every Syndicator Must Know to Stay Out of Jail. And at the back of that ebook, there's the sample questionnaire that you're welcome to steal. I think it still works. If not, I apologize. It's worth a shot. I should probably do me organized. If you email jail at premierlawgroup.net, that should auto send you that ebook. And at the back, there's a questionnaire. So step 1 is send them a questionnaire. Step 2, and by the way, that ebook has all 8 steps. Step 2 would be to have a conversation with them whether it's a phone call, a lunch, a dinner, a Zoom call. Doesn't have to be you, can be somebody in your team, but you want to have this interaction with your prospective investor. What the SEC is looking for is that relationship. They're not looking for 3 touches. They're not looking for 30 days. They're not looking for anything specific. They want you to foster that relationship where the idea is you're asking the investor a ton of questions to find out whether they're suitable, whether your investments are suitable for these people. Are they sophisticated? Do they have that wherewithal? Do they have sufficient knowledge and expertise to determine the risks and merits of your investment? And then they're asking you questions to figure out, well, what the hell do you do? Like, what's your asset class? Are you conservative? Are you a developer? Are you a cash flow? Are you growth? Are you, like, all those questions? And it's that quality of the interaction is what they're looking for. But those are the main 2. They also, I think one of them is, you want to encourage them to look at your website and peruse through your website. You want to have offline communications with your emails. You want to do all these things, but most importantly, you want to document them. It's all about documentation, because 5 years from now, if a deal goes south, or whenever your deal goes south and investors complain, you're not going to remember when the regulator asked you, how did you meet Johnny over here 5 years ago? You're not going to remember, and you should be able to pull up a file and say, look, I met this person on this conference. Here's the questionnaire I sent. Here's the phone call. Some people record the phone calls. You don't have to. To me, it's the easiest way to record the Zoom call. And then if whatever hits the fan, you can always transcribe it. But some people take detailed notes. That's fine. But recording, transcribing, whatever. But you've got to have something in your file. So you can hear all the emails that went back and forth. Here are the notes of our call. Here's, these days you can track where they went on your website, like all that stuff. It's your burden to show that you established that substantive relationship. And so, but those are those 8 steps. Sean, average legal cost of setting up a syndication 506C real estate fund. Depends on a bunch of factors, but I would say probably $20K. Unless you're raising like $100 million or something, that might be more, but it's probably around $20K. All right. Well, thanks so much for joining us tonight. A lot of fun. I'm working on a couple of cool guests for, I don't know if it's gonna be next week. I'm going to continue the Rich Dad advisor series. So trying to get one of the rich dads. If it's not going to be next week, it'll be the week after. And if you've got any topics that you want me to cover, I saw one today that mentioned the ticks. That's a great idea. Just drop something in the Facebook group, and we'll see you next week. Thanks, everyone. Appreciate you guys.